Friends, welcome to the 175th session of Legal Empowerment Through Interaction lecture series. The journey continues every day. We had in the first 100 sessions, thereafter we made it in the weekends, but every time, whether it's every day or in the weekends, we come here together. It's a family get together. We discuss, debate, and end of the day, we go back empowered. We are exposed to new thoughts and ideas. And today we have a wonderful speaker, Justice Endlaw sir. He's a judge of the Delhi High Court. And the topic that he'll be dealing will be which every lawyer every day faces, or every person who would like to contend according to his convenience, whether it is lease or license, depending upon which side you are on. So I'm sure that we'll have a very wonderful afternoon today. And we are privileged with the presence of Justice Ramkumar sir, Justice Ramakrishnan sir, Justice Somayajilu sir, and all of you wonderful participants who have been the part and parcel of this wonderful journey of interaction and empowerment. So may this being a very informal, it's only matter of fact things, and we don't waste time on anything other than waiting the 5 minutes for the participants to fall in. So I would say I would directly request Justice Ramkumar sir to offer the introductory remarks.
Good evening, friends.
Good evening, sir.
To request a confirmed criminal to introduce a subject on civil law, the introduction will definitely be having a criminal flavor. The baffling question as to whether the given transaction is a lease or license has always been and continues to be a vexing question for the bench and the bar alike. The distinction between lease and license was lucidly explained by the Apex Court in the leading case, Associated Hotels of India Limited versus R.N. Kapoor, AR 1959, Supreme Court 1262. A scrutiny of the entire gamut of case law on the question will show that factors such as nomenclature of the document, employment of the words rent or licensee, exclusive possession being given to the grantee, user of the subject matter for enjoyment, intention of the parties as discernible from the document itself, a peep into the surrounding circumstances, etc., are not always determinative of the issue relating to the nature of rights and obligations imposed. There are certain ancillary questions such as, if the transaction is found to be a lease, whether there is a need for notice under section 106 of the Transfer of Property Act 1882, and if there is such a need, whether what are the requisites for a valid notice, etc. Likewise, if the transaction is found to be a license, express or implied revocation of license under section 61 of the Easements Act 1882, then deemed revocation under section 62 of the Easements Act, then when does a license become irrevocable under section 60 of the Easements Act? Then what is more important for a lawyer is whether the prayer in the plain should be for prohibitory injunction or mandatory injunction or for recovery of possession. And if the licensee overstays beyond reasonable time, will he become a trespasser, necessitating a prayer for recovery of possession in the plaint, etc. Let us lend our ears to Honorable Justice Rajiv Sahai Endlaw, although we do not propose to end our law webinars from today onwards. Over to you, sir.
Thank you, Justice Ramkumar. A very good evening, friends. See, looking at the bright side of the pandemic, this has given us a wonderful opportunity. If I wouldn't have met Justice Ramkumar, I wouldn't have met Mr. Shyam Padman. So, because travel across from one place to another is always very rare. So, of course, it has brought a lot of misery to all of us, and especially to a large number of lawyers. At least in Delhi, I can speak because it's a very select few, the kind of work which the courts are doing. The judges are spending the same time, but the lawyers are, it's not all across the section of the bar which is able to work on this electronic media. But this is definitely a good side, and come to it. In fact, I was just mentioning before the beginning of the session to Mr. Shyam Padman that just before the lockdown, I visited the Karnataka Academy on one of the Sundays, and I left in the morning. I returned home at about 10 o'clock in the night for a 2-hour interaction over there in Bangalore. So one feels very stupid when one sees the convenience that all of us from our homes, offices, we are able to connect and share our views, discuss a lot of things. And these discussions, I feel, have always helped me, because, whatever you may say, to speak for half an hour or 1 hour, one has to brush up the subject for at least 2 to 3 hours. So it gives us a very good opportunity. And as it happens, as a judge, the roster is changing from time to time. So I have not been on the civil side for some time now. And plus, in the Delhi High Court, though we have the original jurisdiction, but the bulk of the work which is happening on the original side in the Delhi High Court is IPR or arbitration. So one is not getting so much opportunity to get into the hardcore civil issues like this, as Justice Ramkumar introduced that from the criminal and the civil point of view. So when Mr. Padman had given 2 or 3 options to me, friends, I chose this because I have had a very typical experience with this subject. When this was taught in the law faculty in Delhi, we were read out this, what has been mentioned by Justice Ramkumar, also associated hotels. And it's till date, it's a 60-year-old judgment, but it's till date holding the fray, and there is hardly any judgment on this subject which is not touching base or relying upon associated hotels. But there is something, so I thought in law college that, this subject is like black and white. There can be no confusion whether it's a lease or a license. But when I started the practice of law and started dealing with this legal concept in the myriad of facts which arise in cases, over a period of time, I realized that how this black and white were, nothing was as black, nothing was as white, and it was all gray. So, in spite of this associated hotels holding the free. Now, associated hotels is a very, very interesting judgment if one really sees. Somehow I have not found any discussion on this aspect in any subsequent judgment in the last 3 years. Last year, whatever time I have been associated, nearly 40 years now with law. So, see, it's a 3-judge judgment, and there were 2 issues involved in associated hotels. Because to understand that judgment, we have to go into this. I feel it's very important. I have argued it as a lawyer in 1 or 2 cases, but it didn't come across. The judge didn't feel it's relevant enough issue to be made a part of a judgment. That because it's out of, I think, the sheer weight which this judgment enjoyed, that nobody has thought it fit. And I have, as a judge, I never got an opportunity to go into this issue. So as I mentioned, it's a 3-judge judgment, and there were 2 issues. One issue was whether this concerned a hotel in Delhi, the Imperial Hotel. One part of the hotel was let out to a hairdresser. So the hairdresser started the litigation for fixation of standard rent of his premises, because at that time the Bombay Rent Act was applicable to Delhi. So under that, so his rent was some 600 or 900, and he wanted the standard rent to be fixed. And the rent controller fixed the standard rent at rupees 96 per month. So the hotel went in appeal to the Rent Control Tribunal. Now the Rent Control Tribunal held that in the Rent Act there is an exemption that it doesn't apply to a hotel. So the Rent Control Tribunal, that is the level of the additional district judge or district judge in Delhi, that reversed the judgment. It said that standard rent could not be fixed because Rent Act does not apply. So then the matter came to the High Court. High Court restored the order of the rent controller that no, the exemption of the Rent Act does not apply. So before the Supreme Court, when the matter reached, there were two questions. One was whether it was Rent Act was applicable or not. And the second was that what was the nature of the transaction or the document. There was a written document between the hairdresser and the hotel. So the first opinion was of Justice Sarkar. Justice Sarkar did not go into the question of transaction. He said that as per the definition of the hotel in the Rent Act, the hairdresser would also be covered by the word hotel, notwithstanding that it was not part of it was not a room which was being let out to the patrons of the hotel or the guests who checked in and checked out. So he did not, in view of his finding, he said, so the decision of the High Court has to be reversed and the appeal has to be allowed of the hotel. And therefore, I am not going into this question, what is the nature of the transaction, since Rent Act doesn't apply. And it's not a case whether it's a lease or a license, because even if it was a lease, it was not a registered lease, so the hairdresser had to go out. It is Justice Subbarao who penned the lengthiest of the judgments there. He took a contrary view to what Justice Sarkar had taken. He said no, Rent Act applies. And the logic he gave was that the exemption is only for the guests. And that vis-a-vis the guests who are boarding and lodging, for them the Rent Act does not apply. Any other portion of the hotel would be covered, would be covered by the Rent Act. And then he went into the question whether it was a lease or a license, and he held it to be a lease. Now the third judge, Justice Das, he wrote only a one-paragraph judgment, and primarily he said that, look, on this aspect of whether Rent Act applies or not, I agree with Justice Sarkar that Rent Act will not apply to any portion of the hotel, whether the guest is staying there or it is being used as a shopping arcade or something like that. So, and in one line he wrote, and as far as the nature of the transaction is concerned, I agree with Justice Subbarao. So really what you see is that there was no need. Once Justice Das concurred with Justice Sarkar on Rent Act being not applicable, hotel would have succeeded in any case. There was no need to go into that question. So it is for this reason, but nevertheless he wrote one line that I agree with Justice Subbarao on the nature of the transaction. So that is why you will see in several Supreme Court judgments also, it is mentioned that the minority view of Justice Subbarao, it's not actually a minority view. That view is of Justice Subbarao and Justice Das both. But the fact remains that that question did not arise for adjudication in that case. There is another very interesting facet. By the time the matter had reached the Supreme Court, the hairdresser had died, and probably it was a she. Her heirs were not left with any money. So it's an ex parte judgment. So there was no argument, but nevertheless it was Justice Subbarao and Justice Das on the question of lease and license held in favor of the hairdresser, without the hairdresser being present over there. So what I had argued was that somebody needs to examine that what will be the effect of this. But I think out of sheer erudition of Justice Subbarao, the judgment has held the fray. So if we go to this, what I call the Bible of the subject, to this judgment and see that what exactly it holds. Now that is another very interesting thing, that how this aspect has been dealt with in the judgment. Justice Subbarao first starts with, he says that in a lease, by virtue of section 105 of the Transfer of Property Act, there is a transfer of a right in property. So it's one of the rights in immovable property, whether it's ownership or it's as a mortgagee or it's as a lease. It's one of the flavors of that. And under section 52 of the Easements Act, there is no transfer of any right in any immovable property. It's only a permission granted to use the immovable property for a particular purpose or for doing some act or otherwise. So the difference is transfer of a right in immovable property, or whether it's a permission to use the immovable property or to enter the immovable property to do anything. Then the second thing he went to was, he said that in earlier times he was citing the English law, that the determinative test was exclusive possession, but in English law itself it had been diluted. So exclusive possession was not alone determinative of the nature of the transaction which had taken place. Then the third element which was given was the most important one, which runs through all the subsequent judgments also. You'll find it, that what the court needs to determine is that what was the intention of the parties, whether they wanted to transfer this thing, transfer a right in the property, or only a permission was being given. And this intention has to be gathered from all the surrounding facts and circumstances of the case. And the fourth thing, these are the only four nuggets which can be taken out of this judgment, that it's not the substance but the form of a document, if any, executed between the parties. Now in that case, why he held it to be a lease and he held it not to be a license was, he gave four reasons. Again, one was that it was a case of exclusive possession. The second was that the hotel had no control over the portion which was given to the hairdresser. The third was that the hotel was not issuing any directions, and under the document executed was not issuing any directions to the hairdresser, anything about the functioning of the hairdressing salon in that premises. And another thing which it seems from the language of the judgment weighed very heavily on him was that there was one term in the document which was executed, that the hairdresser had a right to transfer what was granted to the hairdresser, and though with the consent. So he said once a right to transfer is there, it cannot be a permission which is generally personal. It must be a right which he is able to transfer subject only to the condition. She could transfer subject to the condition that she took the consent. So the words he uses are that this right to transfer is destructive of the concept of grant of a privilege. So I think these are the those four tests and these four criteria which he applied and which were concurred in one line by Justice S.K. Das, which we have to follow. So the nomenclature became irrelevant. But again, a very peculiar aspect is, though trial had taken place, but the decision, all the reasons which come out from the judgment are on the basis of the document which was executed between the parties, and not a single thing has come that what were the facts and circumstances. Because not at that time, but after that, having seen the hotel several times, one is aware that of course, now there is some other saloon over there, that it's so much a part of the hotel, and it's basically hardly anybody from outside would go over there. So it's basically for the convenience of the guests of the hotel. So this is what we, so I don't know, and that time cross-examination was important. Now, of course, in present day, what we are seeing in Delhi is that cross-examination is losing its relevance. It's only full of suggestions that what you are saying is wrong, what you have said is wrong. But when I joined the profession in 82, cross-exam, a lot of judgments were won or lost on the basis of cross-examination done. So I presume in 50s, 60s, when the trial in this case would have taken place, there would have been very good cross-examination, but somehow the judgment doesn't refer to any evidence. We don't know whether the trial court file was before the judges or not. So these are certain peculiar features of that. So now another thing is just one other judgment I would like to place for the consideration of all of you, which I thought, because there are several judgments which came, but one I thought I have picked up as an illustrative judgment is a case, it's a 2019 Delta International Limited versus Shyam Sundar Ganeriwal. So that's a comparatively recent. In this case, Delta itself was a tenant in a property, in a immovable property, a large property. In one, it comprised of a land and structures, and they allowed Bharat Petroleum to set up a petrol pump on some part of the land. And there Bharat Petroleum installed its machines, and as per their policy, they gave it for running to, I forget the name of it was some partnership. They were running the petrol pump on behalf of and the document had been executed. And in that case, the document was a license deed. But the question was that in associated, it had been held that the nomenclature of the document was not important. So see how interesting the reason is. The only reason which the court culled out in this judgment for holding it to be a license is they said it was a commercial transaction between corporates, between educated people who were not illiterate, and there was no pleading. Now this I want to lay emphasis because this is for all of us as advocates, it's a very, very important lesson that they fought till the Supreme Court, but there was no pleading that the document was a sham or it was a camouflage, and nothing was stated that what was the need to camouflage it as a license when it was actually a lease. So on that ground alone, they said that it's because of a lack of pleading of a camouflage or of the reason why a camouflage was required, the document had to be treated as what it appeared on the face of, that it was a license. Now, one other thing which is permeating through a lot of judgments is that in one judgment, it's a High Court judgment, one of the High Courts, they said that because the document, though titled as a license, because it said that it's licensee means is heirs, successors, and assigns. So they said if it was not an immovable property, if it was merely a privilege given to a person, where was the need to use this expression? So this is another very big lesson for all of us in, as drafting advocates or as while drafting conveyance deeds, that if we are intending to draft a document in a particular way, this cut and paste will not do. We cannot say that while describing the parties that as normal heirs, successors, assigns, it would be included. So these are just lessons which I thought I'll highlight to place before all of you, so that whether we are acting in the court or we are acting as draftsmen of deeds between the parties, advising clients on that, we have to be very careful in doing these things. Now, there is another very problematic judgment. It's not actually because I couldn't find what happened. In fact, it came to my notice today morning only. It's a two-judge judgment. I think Justice Ravindran and Justice Gokhale of 2011. They have, on the basis of the document, taken two different views. I couldn't find the follow-up that when it was, though it's in 2011, but I'm sure a subsequent view must have come of the third judge, but I was not able to immediately lay my hands on that. Now, in that, Justice Ravindran, again, while citing Associated Hotel, there is some problem created over there because he has gone about illustrating. Now, once Associated Hotel had said that you have to determine the intention of the parties, then according to me, there can be no illustration. Intention essentially means that we have to go into the stage of examination or cross-examination unless, as in Delta, it can be said that there is no plea. So where is the need for evidence? So if in today's time such a case would come, maybe a decree on it under 12(6) would be passed, because there would be the question we will I'll ask the lawyer is that when there is no plea of a camouflage, where is the question of giving you an opportunity to determine intention? Intention is what appeared from the document. Now, in Delhi, another development has taken, all the, in some other places, I think Kerala, I don't think it's been diluted. Rent control laws in Delhi have been diluted to a very, very large extent. There are hardly any, there are in fact no fresh lettings happening which are covered by the Rent Control Act, because we brought down the margin to any premises the rent of which is in excess of 3,500 is not covered by the Rent Act. So most of the lettings are above, all the lettings are above 3,500. So it's only in old cases, and now with there was another view which came of the Supreme Court of even commercial lettings being capable of being evicted on the ground of personal requirement. So the rent litigation in Delhi has been coming down. We used to have 9 exclusive additional rent controllers and rent controllers. Now today we have 1 rent controller who is also a civil judge and doing some other work. So that will illustrate to you that how much. So in Delhi, this license litigation or this issue was coming up repeatedly, because the tenants were using this to conceal subletting. Subletting was a ground of eviction under the Delhi Rent Control Act, as it is in most of the rent control legislations. So the tenants, because the rent was, they were all sitting in a premises at 90 rupees or 80 rupees per month, and the market rent of the premises had gone up. They were earning thousands or lakhs of rupees per month from that shop in Connaught Place or other premium commercial districts of Delhi. So at that time, the tenant and the so-called subtenant used to enter into a license agreement, and whenever the landlord filed a case of eviction on the ground of subletting, this the tenant and the subtenant both in unison would say, no, it's not subletting, it's a leave-in license. So that was, of course, colluding. So at that time, you will find a lot of most of the other judgments which have gone to the Supreme Court on this license basis. The most famous, I think, being of that Rajbir Kaur or something like that, where one of the ladies in the house was earlier functioning as a tailor, and then she passed away, and her machine and the entire setup was there. So in the same room from where, because there was a fixed clientele of the household, they were earning basically dependent on that. So the rest of the family allowed another tailor to sit and work over there, and they used to pay him something, some part of fee which was charged. So in that case, it was held that no, it's only a permission which has been granted, so that it was not a subletting, and the petition for eviction was dismissed. But now with the dilution of the rent control laws in Delhi, in that context, this question is coming less and less. A lot of landlords at that time, while letting out, because they knew that if they let out, it will be covered by the Rent Control Act. So they would create a leave-in license, and then subsequently the tenant would say that no, I'm a tenant and it's not a license. So this issue was very active. Now today, what we are encountering, the basic type of large type of litigation which is coming in, this is amongst family relations. Then it has come in the context of the Senior Citizens Act, that when a son or daughter-in-law or somebody else is sought to be evicted by the authority, they would come and say, okay, we have a right in the premises. Till this recent Supreme Court judgment came under the DV Act, that the right of a woman in her in-laws' household. Before that, this question was arising in that also, in that context also, that so it's a different facet. Then in a large number of cases, it is coming vis-a-vis agents and employees, that what does it constitute. But in any case, I'm sure it remains in other states where this question, the rent control laws are still there. So now, as I said that the question is whether it is what was the intention of the parties. Now, we have to be very, very careful in drafting the plaint or the written statement, depending upon what stand we are taking, that or what we wanted to be proved as. In a large number of such cases, there are very few cases where there would be a written document. Largely, these disputes arise when there is no written document. So we have to see, if we are, for instance, inducting somebody in the premises as a license, we have to make proper pleas that in what circumstances it was being let out or the person was being inducted. For instance, if there is a shop running and suddenly there is no member left in the family or in the tenant or in the owner of the shop who can run it, then that reason has to be cited. See, it can never be a standard document like it happens most of the time that people would download from the machine that, okay, what is the format of a leave-in license? You have to basically show what is the color. You have to understand when the client faced with this issue comes that in what circumstances the transaction take place, plead that, then what I have as a judge found in a large number of cases, see this sham and camouflage plea is taken in a large number of cases. But typically people don't say what was the need for a camouflage. So without there can be no camouflage without a real intention or without a need to hide. So if you are taking a play of a camouflage, in Delhi we are making very good use of, on the original side. Generally, not the corporates, but individual litigants, they are present in the court because they have that personal anxiety about each and every data hearing. So the best is to call the person immediately and put a few questions to him. And that invariably brings out the truth because he is not prepared for the statement. If you give a date for a statement to be recorded, the person would come trained, and then you can never elicit the truth. Because if during the hearing you pass an order that there is ambiguity and therefore I am directing his presence, the lawyer is bound to know that, okay, this is what is going to be asked, and so the surprise element works the best. And my experience as a judge has been that a large number of cases get resolved at that stage only, at the stage of when one goes through the pleadings, at the stage of framing of issues, without disclosing your mind. If you call the person, or even if you have to give a date, the person is not there, don't record why you are calling him. And maybe you can say that for the purposes of compromise, exploring the possibility or something, and then ask the question. So if you ask the litigant at that stage, that the lawyer has to, according to me, probe. See, the litigant does not know when he comes to a lawyer that what the legal effect of his problem is. He'll only tell you that it is pinching, my shoe is pinching. Now it's for you to find out that whether it's the defect in the shoe or defect in his sole or defect in his feet, and what is the legal impact of it, which again from experience of a cross section of bar. See, as a lawyer, when one is practicing, again, these are my personal thoughts, but I think they are very, I have a lot of strength, or what should I say, I think I give a lot of weight to it. So I try to share it whenever I get an opportunity. You don't see how the other lawyers are behaving. You are busy in your own case and you meet a certain standard. Whatever standard of litigants you are dealing in, you will meet the same standard. But as a judge, one sees a larger cross-section of the bar. And one finds that there are a lot of cases which the facts are in favor of a client, but they have not been put because the lawyer has not asked the probing questions to the client. So it's very, very important to don't just be a translator into English or whatever language you are filing a pleading, what the client is telling you. You have to understand there will be so many things which may be there which he did not feel relevant to tell you. You have to dig out that relevant things and then make it a part of a pleading, or make it, store it in your mind for use in cross-examination or for putting down in the affidavit of evidence. And as I said, my experience now as a judge is that a large number of cases are being decided contrary to what they should be for this not being inquired from the client. So if one finds out, because ultimately the test is in the context of lease and license, to go to the intention of the parties, their intention can come out of this only. I can understand if it's the corporates, they are educated, the lawyers have drafted the documents, then the scope of saying that no, it is something else is very, very little. And even if somebody is pleaded it, because if you go and say that, okay, get your income tax returns, show how it has been dealt with in your balance sheets. So you can't do this, that for taxation, it's one purpose, and for a civil dispute, it's another purpose. If your stand has to be the same, whatever you are, if you are getting any benefits as in taxation because of that, you cannot wriggle out of that and say, now give me this benefit also. So proving camouflage today is becoming more and more difficult as all transactions are reduced into documents. But when we deal with individual litigants, a lot of illiterate litigants who he needs a shop somehow or the other. He is willing to sign anything which the landlord will ask him to. So in that kind of a status, all this becomes very relevant, how to do it. There's another very interesting facts which keep on coming up. Now, I mentioned in the family context, say a father along with his sons or daughters is living in the house, which is a very common format in our society. Now, the son is able to draw a HRA, a house rent allowance, if he submits a receipt. If he is living with his father, he can't get HRA. So he'll ask his father to issue a receipt to him. And father will give the receipt and he'll deposit that with his employer and draw the HRA. When the dispute arises between the father and son, and the father wants the son to go away, or the son wants to threaten the father that I have a right in the house, then that receipt surfaces and it is said that, look, I'm a tenant in this house, so I have a right. There is a right of transfer. So in that case also, this was one of the matters I did in the district court, so you won't find any reported judgment, and it got settled as invariably happens in these family disputes. But when we cross-examined, we were able to elicit very good facts. The son could not say, before he was employed, before that was, because earlier he was in another company where there was no such HRA thing. So he was living in the same room in the house, same kitchen and everything. So with the receipt, nothing happened. There was no check transaction with the father, nothing at all. His spending in the house had remained the same. When we started quizzing him, he tried to take a stand that, look, I am a tenant in the whole flat, I allowed my father to reside with me in the house. But he couldn't prove any of it because ultimately the things came out that there was no change from the date when the receipts were issued. And then, as I said, you have to keep it strictly personal. When you are wanting a license, you have to show a reason that why I picked up this man for this license, what was his special thing, and what control over business. See, nowadays what is happening in a lot of these hotels, when they'll fix a rate. We all have canteens, court has canteen. Now, how do we draw up when the High Court or the District Court chooses a contractor? We specify that, all right, you will serve these items, this would be the price. So that's all this is to show that the control which is being exercised over the premises. So in the case of a hairdresser, in that case, the rate should have been, because the hotels generally charge on a percentage basis. So you say that, all right, I am providing this business premises, all these shops, counters, everything are mine. Even if it is not being done for the sake of creating a document, you can say, all right, you can take it away. This would be, if you stay for this much time, so that there is no feeling that it has to be returned. Or the landlord may say tomorrow that you have damaged my counter. So there are ways and ways to devise it, or maybe it can be shown as furnishing. You cannot say that you will carry out the repairs, because then again it will run antithesis to a lease. So you have to think of all these things as a draftsman of the conveyance, that how to do it. There's one or two things which I wanted to say. Just 1 minute. Yeah. So now, what I thought I can place before you, all of you, for consideration is, what I understand is that if it's a very clear-cut document, educated parties know. But if there is no such thing, then the only distinction I can place for your consideration between a lease and a license is that whether the advocate for the person who's saying it's a lease is brighter, or the advocate for the person who has seen that license, he is brighter and he works hard. So as the joke goes, that whether it is a lease or license, you have to ask your client, what do you want it to be, and make it accordingly. So that comes to be the thing which we have. It's basically on all of us as lawyers, that we are not able to put what is a lease or a license, because once the question of intention is there, it is for us to plead and prove that intention to be able to make out whether it is a lease or license. Now, just as Ramkumar mentioned a few other things, frankly speaking, I did not look into this, but offhand, what I can offer my comments. First was, I've taken down 3 points. I'll take up this notice and irrevocable. Now, notice now under the lease, after the 2005 amendment of Section 106 of the Transfer of Property Act, it's really lost its significance. Then that judgment came of the Supreme Court, in that, I forget the name, though I had done that case in the trial court, High Court and Supreme Court, somebody else did it. In that case, there was no notice. The notice could not be proved during the trial. So we lost in the trial court. In the High Court, it was held that, so what? By that time, the amendment had come. Even if there was no notice, because it says the suit has gone on for 7-8 years by then, so that is notice enough. So the institution of the suit itself is a notice. So that question in lease as well as license has lost. And in the case of the notice in the case of a lease also has lost its significance today. Now, as far as license is concerned, a lot of license deeds provide for a notice. But I have taken a view, I am not aware of any other. There is another section in the Easements Act which says that for wrongful termination of a license, damages are the remedy. So I have taken a view that even if the license is irrevocable, it has been cancelled, the remedy is only of damages. But again, it's a single judge's view. I won't spouse it. The question is still at large. I am not aware of any other court or any other judge having, not even of our court, who may have taken that view. The third point was about what should be the form of a prayer in a suit against a licensee. Now that question is, again, there is a Ramkumar judgment or something like that. And it relies on some 70s judgment, again, of the Supreme Court, where they have said that against a licensee, a suit for mandatory injunction or a prohibitory injunction is enough, and you don't need to sue for possession unless one exception has been carved out that unless after termination the licensee has continued for a very long time, and post termination the possession has become confirmed. But there also, if it's a genuine license like a hotel or something, where the control and everything is there and the same parameters apply, maybe that question will not arise. But Ramkumar was a case of a shop in Delhi where the tenant had a servant, so who was actually doing the business. The tenant had become very old. He had stopped coming to the shop, and it was the servant who had carried, and it had come on record that the servant was paying a fixed month. It's not as if he was this thing. So there was a plea of lease license. Ultimately, that question apart, what was held was that a suit for mandatory injunction is maintainable. Ultimately, that was the question on which the Supreme Court pronounced. Lease license, they agreed that it was a license and it was notwithstanding the fixed amount. But that is not really a main part of the Supreme Court judgment. That was in the trial stages. And but a suit for mandatory injunction, the earlier cases of Jammu and Kashmir High Court, that had traveled to. In that is the 70s case in which they had said that merely filing a suit for mandatory injunction. And then they also clarified in this Ramkumar that because the problem which was arising in Delhi, one of the judgments had come which had taken a view that if you have opted to go for mandatory injunction and not for possession against a license, warrants of possession cannot be issued in execution. You can only haul him up for contempt, attach his goods and all, executed like a decree for injunction. So that also they said that no warrants of possession can be issued pursuant to a decree for mandatory injunction. So that was it, sir. If anything else, I would like to hear any contrary views.
Thank you. Thank you
so much. Thank you.
We recognize the presence of Justice B. Krishnamohan sir and Justice B. Rajendran sir. Over to you, Ramkumar sir. Then we'll move on to that.
An articulation with great practical insight. This is how in fact, I'm sure that the lawyer friends, advocate friends who have viewed this must have benefited much in the matter of drafting the document as well as the matter of drafting the plaint. Very practical insight given. Wonderful lecture. Thank you.
Thank you, sir.
Thank you, Justice Ramkumar sir. Over to you, Justice Ramakrishnan sir.
Yes, really, as Ramkumar has said, in spite of the fact there are a lot of decisions and guidelines as to how this will have to be determined, still it is a gray area. Because nobody understands what is the intention, how will you draw the intention, what are all the nature of evidence that you will have to let in for the purpose, and also whether the possession, exclusive possession has been given, when any control has been kept or not. All those things are still in the gray area, because that is the reason why probably the drafting of a document as well as drafting the plaint looms large, as you have said. Unless the pleading is specific, expressing what is the nature of intention of the parties when the document was entered into, and what is the nature of prayer that you want to call for, and then all these things will arise. So it is an eye-opener for the lawyers and also judges as to how these things, practical things will have to be viewed. The difficulty in understanding the difficulties of the people, how they can do it, also will have to be looked into when such cases are coming before us. Really, it's a nice lecture, Mr. Brother.
Thank you. Thank you, Ramakrishnan sir. Over to you, Justice B. Rajendran sir.
Very good evening. Apologies for my delay in joining. Due to, of course, purely due to the technical error, my documents rectified it. Thank God. I couldn't do it. Anyway, nice seeing my good friend Endlaw, who was with the bench in Justice Murugesan. We used to meet him when he was there.
Yeah.
His speech, very good articulation in the subject. He has dealt in detail regarding the leave and license. And in fact, The earliest case, it started in Madras, which is in respect of a coconut though. A person when he was allowed to pluck the coconuts, whether lease or license, was the earliest judgment which went up to Supreme Court, and Supreme Court held merely plucking of the coconut will be only lease. But if he is allowed to put up a hut there and thereafter he takes over the property, it will become a lease. So that's how they extended discussion, and thereafter much law has fallen down, as rightly pointed out. When the amendment has come to 106, even notice has been dispensed with. Earlier the question of notice is mandatory, all this has been changed. And I am shocked to hear that in Delhi, the rent fixed is 3,500 rupees, which is the pictures. Now, property worthwhile, he will be charged 500 rupees. So literally everything is outside the scope. This is one thing. But in Tamil Nadu, as it is concerned, in those days, now we have completely lost touch. Lease and license, question of fixation of rent is not a criterion. Even in the House Rent Control Act, originally it was 2000, even that was taken away. Commercial property is also included in the Rent Control Act.
Yes.
Thank you so much. A very well receptive one. Thank you.
Thank you. Now, may we request Justice B. Krishna Mohan, sir, for your comments, sir. So you'll have to unmute. Yes, sir.
Sir, good evening, everybody. This is first day, my introduction to the program. My brother Judge has given an erudite lecture on the topic of lease and license. Very a relevant topic for current day situation across the country, because a lot of commercial transactions around these two words. Yes, it's all ultimately, as my brother put it, intention of the parties we have to see, and the nature of the transactions. Ultimately, these things would determine whether it is to be construed as a lease or a license. Accordingly, the orders can be passed by the appropriate courts, depending on the relief sought by the parties respectively. Anyway, I will join, sir. I will continue, and I will. I will continue in the session. Yes, my daughter is also into law, fresher.
No, Mr. Krishna Kumar, once you come here, there is an obligation that you will have to take a class also on a particular day.
First, as a student, I will hear as a student.
Now, Endlaw, sir, you could understand how we entrap persons to come and take classes.
Yes. Undoubtedly. Very
now let
enticing.
us have some open discussion, sir. Over to you, Vijay.
Before that, if I may just
Sure, sir.
Responding to what was said was that gray. According to me, it becomes gray only if we don't really examine facts. If we examine facts in detail and transform them into the document or in the pleadings and in the evidence, then sir, it will not remain gray. And the best test to be applied is, I think we all have experienced this, that when I am living with my father, with my parents in a house, or with my sister or brother, you have to see that that's a license. So if you apply that test in the mind, that what is the nature of your occupation, you are living in a parental or a sibling house, and that you are a licensee, you can't claim any right to it. And translate that into whatever facts, or even if some of us have not gone and stayed in a hotel, when we go to a canteen to eat in our student days, we are sitting there. So we are maybe there may be booths. In law college, there used to be one canteen which had booths. So it was your private space. You are sitting over there. So you may be in exclusive possession, but you can't say that there is a transfer of a right. It's barely a permission to go in. Or now we have this co-working spaces. Yes, that was another thing which I missed out. In Delhi, this has become very, very popular that this, I don't know whether it's traveled to other, it must have, I'm sure, co-work or something. Yes. So if people go, all right, now the cabins are there, it's just that all the facilities are there, but you are entering it to work in a particular cabin, you can lock it after you have finished your work till you go back the next morning. It's your private, but it's still something like going to a business center. Or when we used to go to a PCO, we were closeted in that cabin. It was ours, we were in exclusive possession. But could anybody say that I have become a lessee of this PCO? So if we see the things from our common day point of view, I think the facts start falling in place and we will identify ourselves that what we need to show and what we need to ask the client and write it down and prove it in the court. That was the only thing I wanted to add. Thank you.
Very often this camouflage and subterfuge, they're all lawyers' contribution.
That's right, sir.
That of course, and the beauty of it is that asking the client, what do you want it to be, lease or license?
There is that joke, no, that 2 plus 2, the lawyer said, he drew the curtains, he asked the client in a silent voice, what do you want it to be?
And client doesn't know the legal implications.
No, even the
Vijay,
no, even not only that, if you are talking about the income tax document, etc. See, normally, even if the word used is license fee in your document, whenever they are doing it, they say the rent for the building.
Yes.
So if they say that will not going to make any difference, because a clever associate will say the rent for the building.
See, that question I understand that in the case of a company suing for recovery, if they have written it off in their books of account and that writing off is without a note of the auditor in the balance sheet, the company cannot technically claim it because it's not outstanding in the books. So you cannot take one stand before the authorities and another stand before your parties with whom you are dealing.
Correct. Vijay, please.
Very well spoken, sir. And last which you made up with regard to lease and license, I think that's the basic fundamental difference. See, it's the convenience of the person who was seeking eviction, because lease was a little complicated, they say it's license. So it's a mechanism which is adopted for a quicker eviction process. This is all, as Justice Ramkumar said, it's only a contribution of the fraternity rather than the law by itself. Thank you, sir. Thank you.
Thank you.
Thank you, Vijay. We have Navneet with a question. Navneet, please.
Hello, good evening, sir. Yeah, my question is in places like Delhi or in other places as well, where commercial properties are let out as on the basis of leave and license. So my question is, should in such cases the intention of the parties be considered as irrelevant, especially because you're letting out a bigger property and possibly for a longer duration? Should it be deemed as a lease agreement so that the benefits which a tenant gets under a lease agreement is actually extended to the license holder? So my question is it a clever way to deny the rights to a license?
Camouflage.
Yeah, camouflage, or deny the rights to a license holder, especially when he's taking a bigger property and in similar fashion as a lease. In similar fashion as a lease. So should the intention of the parties be ignored and it should be deemed as a lease agreement and the rights extended to the leaseholder just like a tenant? Thank you, sir.
Why would a camouflage happen? There has to be for it to be a camouflage, you have to have a reason. It's not a itsy-bitsy of the party. And as we discussed earlier, throwing out a person, whether as a lessee or a licensee, is the same unless you have a registered lease deed for a longer period. If you have a registered lease deed for a longer period, then you cannot be thrown out unless you are in default under the Transfer of Property Act. So that is one thing, and larger premises also. See, in a large number of malls, for instance, which are coming up now, huge restaurants are being given out on license basis. That they say, all right, you come and operate over here. A lot of times, what happens is the staff, the brand keeps on changing. The equipment will be there, the furniture will be there, and it's a different person who walks in only with his chef, makes slight change in the decoration, and he starts running it then. But it does not always become a lease. It can be a license arrangement also. And in these large spaces, generally people have acted on legal advice. They have created a document. So why should, see, gone are the days when we had a case of a illiterate litigants in India, and when it was said Mofussil pleadings, the lawyers also don't know how to draft. Today, there is a lot of professionalism in the profession. So, a written document executed by literate parties, or even if there are illiterate parties, see, it's not as if when the illiterate parties are there, they can't be made to understand. You drop the document in vernacular, or make an educated family member sign as a witness, who will also say that, yes, I have explained all the contents. So, it basically boils down to taking care, which is my theme for today. It all comes down to the advocate, how he handles it. Is there any other part remaining? Sorry, of the question?
No, sir. I think we'll move to Dilip. Dilip, sir.
Good evening, everyone. Thank you for a wonderful speech, sir. According to me, you have spelled out a number of tests to determine whether a transaction is a lease or license. But I think the litmus test should be, one, whether the transaction will subsist or survive divorce the death of either party, or at least of the transferee. And the second one is, does the privilege or the right granted by the document includes or amounts to a covenant running with the subject matter. So these litmus tests would definitely bring us to a conclusion as to whether it can be said it is a lease or license without so much doubt or confusion. And in my experience as a civil lawyer, what I do is, when a person comes with a document, I will just try these litmus tests to show whether, to understand myself whether it is a lease or license. And against the adverse party, I would issue a notice stating that your lease or license is terminated as styled in the document. If it is mentioned as a lease, I would say that your lease is terminated by reason of this. And if it is mentioned as a license, I would say that it is license terminated with effect of such and such date. And naturally or normally, in almost 80% of cases, there will be a reply stating that it is either lease or license.
Yes.
So I can vouch
Then we'll accept that.
I can vouch upon that representation and bring a suit as he proposes, and then he will be able to say.
So your notice is the trap.
Yeah. Section 115 of Evidence Act will apply.
Yeah.
Absolutely. Brilliant.
No, normally used to say in Calicut cases, whenever the rent control matter or the termination of lease arises, where it is the Rent Control Act is not applicable, such a thing will arise. Then they will come with an explanation. Because once an admission, once an
Calicut,
admission,
it is mortgage. Mortgage.
that was one way of overcoming this. What do you call this? A camouflage to overcome the rent control provisions. And another thing was, as Dilip was telling, then also they will come with an explanation stating that I do not know because it was drafted with a lawyer. So really what I intended was I was a tenant in the building.
Ramachan sir, Ravashan sir, when you talk about Calicut, we have a special thing known as Kozhikode mortgage or
Yes.
Calicut mortgage.
Yes,
That
yes.
is
The
what
document will be
Ramkumar is
styled
saying.
as a sale
But
deed, but
there is
in
a
fact
judgment
not a
by
sale deed.
Justice Kochuman. There is a judgment by Justice Kochuman.
Yes,
Which is
absolutely, sir. Absolutely.
a colorable transaction.
Colorable
No,
transaction.
Just
even
just
see,
to
not only
circumvent
that,
the Rent Control Act.
there it is a conditional sale. Once you
Yes.
return the document, the mortgage will be released, and the
Yes.
amount, because no question of returning any amount, nothing like that.
It's
Everything
only
will
to circumvent the Rent Control Act.
that's all.
So we'll rush through the other questions. We have Sri Kanteshwar with a question. Sri Kanteshwar, please unmute and put the question. Are you there?
I think Radhakrishnan wants to say, put up the hand.
Radhakrishnan Murthy, yeah, of course. Please. Yeah, long time.
Yes, we are seeing you after a long gap.
I'm there.
All well in Hyderabad.
Yeah, fine, sir. Everything. Vijay is there, no, in Hyderabad. Of
Yeah,
course.
Vijay is always representing the entire Andhra Pradesh and Telangana.
He's not in Hyderabad and all, he has moved to his native place. I don't know whether he has come back.
As long as Vijay is there, Telangana will never go unrepresented.
Yes, Radhakrishnan Murthy, all yours.
Yeah. My question is actually, see, in SURFACE Act, there is a protection for license, lease and because that there are n number of judgments have come and all, once it is registered lease and all, that they cannot be thrown out under the SURFACE Act and all. But so far as license is concerned, I have not come across any judgment whether, that there is a protection under SURFACE Act or not. Is there any judgment on that?
License.
No, I've also not come across any judgment. But see, it's under the SURFACE also, it's the same effect. See the mortgagee or the ARC stepping into the shoes of the earlier owner. So if the earlier owner could have thrown out, then the section 17 will be decided accordingly. Then, of course, if the question arises whether it is a lease or license, that will have to be decided in section 17.
No, as far as lease is concerned and all depends upon the state to state and all, which requires registration and all. Therefore, that there is a protection. But so far as license is concerned, no documentary evidence is required at all. Even expressly also it can be. Therefore, once if they set up a plea saying that he was granted license to stay and all, then such protection can be taken and he cannot be thrown. If that be the case, because immediately before, throwing out and all, we can set up any licensee and we can take this plea and institute a suit. So that is not covered and anywhere and all. By any chance, is there any judgment or anywhere it was, contested like that?
No, not to my knowledge.
Okay.
But exclusive possession may be determinative, is it not? Exclusive possession will be determinative ordinarily. Exclusive possession.
No, what Associated says is it's only prima facie, it's not determinative.
Sir, we'll move to KVJ Rao, sir, please.
Sir, good evening, everybody. Thank you. Very nice. This is some new. We are here leasing of aircraft because I'm from the aviation industry, and our properties also. There are a lot of issues, but then I find that it's a very thin line between the lease and the license, and it depends on, like as Endlaw sir, Justice Endlaw sir said, how you draft your plaint and what would be your plea will decide whether it is a license or a lease. But there are so many, there are so many tenants who, after having taken the benefit, would still want to harass the landlord, even though the landlord has been very magnanimous in a lot of issues. Imagine earning a rent of 20 rupees or 30 rupees for the last so many years, and then one fine day you're not even willing to increase that to what would be a reasonable, I'm not even saying market rate, take it at an average market rate. And that ends up in litigation. It's just the greed of the person that increases the litigation. Magnanimity should be on both sides. If I as a leaser wants to do something, sorry sir.
Yes, please.
Yeah. So, litigation is become the norm of the day to sort out an issue. I mean, it's very good on Justice Endlaw's part to try and come to a compromise at the beginning by asking questions, even though deceptively asking him to come to court under some reason or the other. But then that needs to be done, because when skullduggery is involved, you are left with no other choice but to take that route. So we have to. It's a very good suggestion given by Justice Endlaw that at the first stage itself, call either one of the parties, find out the reason as to whether it was a lease or a license, why it was given, what was the intention. And I think 90% of the cases would have been solved by then. So this is really good, nice, informative talk, Justice Endlaw. And Shyam sir, thank you very much as usual.
Thank you.
Thank you.
Then
Thank
the
you,
lawyers,
sir.
then the lawyers will be jobless.
Yes.
Sir, as we come to the end of the 175th session, may I request Prime Raj for the concluding remarks?
Well, first of all, am I audible? Because I can
Yes,
only
yes.
I can only see the blank screen because my computer screen has got turned off, so I cannot see anything. Anyway, Endlaw sir,
You're blind. You're blind.
I am not blind because my monitor still. Endlaw sir, that was an absolutely enlightening session where you have taken us right from that associated judgments of 1959. And in fact, if you closely read that associated judgment, that was a judgment by three great judges, and all the three judgments writing separate judgments. I think it was Justice Subbarao, Justice Sarkar, and Justice Das.
Yes.
And with regard to what Justice Ramkumar had posed in that initial session, I think that was answered first by the Kerala High Court right during 1974, a division bench of the Kerala High Court by Justice Balagannaran, I think, 74 KLT, and which was ultimately 2005 Supreme Court. I don't remember the exact citation. I think it is 2005 6 SCC. Joseph Severance versus Binny Matthew. Justice Pasayat had an occasion to say that you have a reasonable time, a licensee, even after the expiry of the license, you have a reasonable time to vacate. There's something called a reasonable time. Only after that, elapse of that reasonable time, you become a trespasser. And recovery is not only as against a trespasser. Otherwise, a mandatory injunction suffices. As a 2005 decision, I don't remember the exact citation. It is Joseph Severance case. Joseph Severance was Binny Matthew.
That is why I put it this way. He overstays even after beyond reasonable time.
Then he becomes a trespasser.
Then he becomes a trespasser. Then recovery may be necessary.
It is. That is that's what the Supreme Court said in this 2005 judgment. And it was there was 74 Kerala judgment of the division bench judgment, which I think again was reiterated by Justice Thomas P. Joseph in 2012, Nadarajan or something. I don't remember that. There is another judgment also to that effect. Anyway, Endlaw, so there was an absolutely erudite and enlightening session. Thank you so much.
Thank you. Thank you very much. As we come to the end of the 175th session of our journey still continues. We'll be meeting next week. Thanks are due to you, sir, Justice Endlaw, sir, for enlightening us on this nuances and the final distinction between lease and license, and especially how lease becomes license or license becomes lease at the volition either of the party or the lawyer. I won't just say about the lawyer because whatever manner you want to have it, you can. It is something that is so amorphous. It can take any shape. And I would like to thank Justice Ramkumar sir for the introductory remarks regarding the subject and correlating with the other statutes as well. Justice Ramesh sir, Justice B. Rajendran sir, Justice B. Krishnamohan sir, and Justice Somayajula sir for their valuable presence and inputs. We look forward to have you in this platform again and again, in the sense like let us interact, let us empower ourselves and the justice dispensation machinery as a whole, the whole stakeholders, let all of us get empowered so that we'll have a better tomorrow. So thank you very much. And Legal Empowerment Through Interaction lecture series, I believe, has done its role today. Till we meet again next week. Special thanks to Endlaw sir once again.